All right, everyone, welcome back in to another edition of Balancing the Scales of Justice with Shirley Millwood. Shirley, how have you been doing today?
Hey, it's been a busy day. Been grinding away with legal stuff today. How are you?
I'm doing pretty good, man. I've been, unfortunately, we had a loss of one of our members of Average Joe's, Reggie Davis, so we've been recovering over that as a family. It's been rough times for us.
Reggie was a good guy.
Good guy. You'd met him. A lot of people around all of our communities in our area had got to meet him. But that's how life is. We're going to honor him. We're going to move forward and do a lot of things in his name moving forward. And I appreciate you asking, though. But tonight, it's very special to get to do the show with you because you're born and raised here, and being able to practice law in a county in which you were born and raised and making a difference in the community. How special?
It's been very special. As you said, I was born and raised here, and I raised my family here. And whenever I finished law school, I went to Alexandria. I went to school at Alexandria.
Valley Cubs.
Yes. So when I was in law school, I remember, one of my goals is I said, if no one's opened a law practice in Alexandria by the time I get through law school, then that's what I wanted to do. And so I was able to open my own practice there in October of 2009. So
awesome. It's
been a while. So almost 15 years, 14 and a half years later, I'm still there practicing. And it's been a blessing. Everyone's been very loyal. I've been very fortunate, and I've been able to help a lot of people. And of course, that's always what I like doing is helping people. So I've been very blessed that I've been able to do that.
No doubt. And you're centrally located there. For those who do not know where your office is, you're right off 431. You can see your office from 431. Near what I like to call the four-way. I know it's not called a four-way, but
Highway 144.
That's exactly right. 144,
yes.
Right where it connects with 431, so it's very centrally located as well. Let me ask you another question. Being there, not only in the same county, but in the same town, which you just mentioned, is very important for you. Being a Valley Cub, being right there in the heart of Alexandria, you see the familiar faces. You probably helped some people you didn't even know would ever be possible, but talk about that, how special that's been.
I have loved it. I love being there. I'm so thankful that I was able to bring this to the community, to our people. And before, and still some do, but they have to drive downtown to see a lawyer. And so it was nice for me to be able to bring my practice to Alexandria and make it more convenient for people living out in the more rural areas so that they didn't have to always drive downtown.
Absolutely. There's a couple of issues or things we would like to talk about today. We just talked about, mentioned, unfortunately for us, Reggie passed away, but for someone who did pass away, how important is it having a last will and testament for someone that passes away?
So I always encourage everyone to have a last will and testament. By having a last will and testament, you're able to direct the distribution of your assets upon your passing away. If you do not have a will, then govern the distribution of your assets upon your death, and you still file a petition with the court to administer that estate the same as you would if you do have a will, but there are additional requirements to that. And the main thing is that with a will, you get to say, I want Johnny or Lucy or whoever to have, this piece of furniture or this automobile or this money in the bank. Whatever it is that you may have, if you have real estate, you get to direct who's going to receive those assets upon your death. If you don't have a will, then it would be the state law dictates the distribution of your assets, and that's pursuant to the Alabama Code of Action.
Absolutely. So it's better, so to speak, to be ahead of the curve than definitely behind, because if someone was to pass away, like maybe a younger family member or something who would retain some assets, then it becomes a nightmare at that point, hadn't it? I'm sure you've seen some of that.
Yes, and so, according to the state laws on estate administration, if you do not have a will, the law directs that if you're married, we first look to your spouse and your children.
Okay.
If your spouse is also the parent to your children, then that affects the distribution of the estate also.
Gotcha.
If you don't have a spouse, we look to your children. And then if you don't have children, then we look to your parents. If your parents, and when I say you don't have, well, for parents, if parents have predeceased you, then we look to your grandparents, and then if your grandparents have predeceased you, then and that's how the state law dictates that. And so often over the years, I've had people to come into the office and they say, well, Mama always wanted, Aunt Diane to have this buffet set or a specific piece of furniture. If they didn't have a will, they don't get to dictate that. And,
Right.
That goes according to the intestate laws of the state.
Do they have to file the probate there with the estate or no?
It depends. And so what I do is when clients come in, I will ask them, do they have any real estate? In order to transfer real estate that belongs to a decedent, you do have to petition the court to. So when you petition the court, if you're filing a will in with probate, you would be granted a letters of testamentary. If you're filing probate in a state where someone died intestate, then you're granted letters of administration. You need those letters in order to convey real estate. Now, a lot of times what we see on jointly with rights of survivorship. If there is property that is deeded jointly with rights of survivorship, then you would not need, for that specific piece of property, you would not have to probate the estate because that property automatically passes to the other owner, whether it's the other spouse or whoever it may be.
Correct. And
it bypasses the estate. That's one of the questions we look at. The other question and if let's just assume they don't have real estate or they have real estate that was a survivorship warranty deed. So often I have clients who tell me, yes, we have bank accounts, but my spouse is on my account. And they are, but a lot of times they're listed as an authorized user.
But it's not joint.
Yes.
Oh, okay, that's totally different then.
That is correct. And so I tell my clients all the time, go to the bank, talk to the bank, make sure that you are listed as an owner with rights. That's what you want to happen to your bank account upon your death. If you want your bank account to become part of your estate, then you can leave someone as an authorized user. If you have an account that they have an ownership with rights to survivorship, then that would automatically pass and bypass the estate.
Okay, gotcha.
And so assuming, that situation, then you would not need to probate the will. The other reason that we look is if they have investment accounts, retirement accounts, pensions, any sort of accounts like that. Generally, most of those are going to have the ability for them to name a beneficiary that will receive those assets upon their death automatically and bypass the estate. But in the event that they don't have a beneficiary listed, then that would become part of the estate.
Gotcha. Which would be very interesting, and we're going to take a short break coming up in just a minute. But before we do, Shirley, worst case, then it becomes very hazy, and it becomes very difficult from the standpoint of separating these things, but you are giving guidelines to how that's supposed to look. Yes. So we got about 30 seconds before break here, but in your opinion, though, it's better to, like you said, if you do have a bank account, go ahead and make them a joint member who has access as well. Definitely better to get the will. If it's someone
you trust with your life.
Correct, literally. So in that situation, these are definitely some good tips that I didn't even on this short matter. So we're going to take a quick break here in just about 5 seconds, and we're going to be right back.
The Coosa Valley, on the banks of the Coosa River in Gadsden, Alabama. Fishing, boating, and paddling, and home to Team One Chevrolet. Team One Chevy has been serving generations for years. Even the grandkids are growing. Many people come back to Team One Chevy in Gadsden.
Home of the best people, the best service, period.
At Campers Unlimited, we offer a no-pressure experience, no hidden fees, and great service after the sale, making us one of the fastest-growing RV dealers in the Southeast. With our second location in Oxford, we offer a great selection of over 220 campers from top brands, including Grand Design. Our mission is to help friends and family spend time together in the great outdoors. At Campers Unlimited, you aren't just a customer, you are family. Unlimited.net or come see us at Gadsden or Oxford.
All right, we are back here with Balancing the Scale of Justice. And you know, we went to break. We were talking about, you know, in case someone does have a will, if they do not have a will, if you have to probate the estate. So what is the process in probating an estate in that situation where someone does pass away?
So first of all, we have to wait until we have a death certificate.
Okay.
And then you need to consult an attorney and file a petition to probate the will. Along with that petition, you have to provide the court with the original death certificate. The court must have both of those. And every heir at law or everyone that receive a distribution of the estate must either sign a waiver and consent. Generally what we do, someone comes in, we'll prepare the petition, we prepare an answer and waiver and a consent permitting that person to be allowed to serve as personal representative of the estate.
Okay.
As long as we have those consents and those waivers, we file that with the court also along with our petition, and then the judge will enter an order granting letters of testamentary. If we don't receive waivers and consents, we have to serve all of the heirs at law and everyone who's to receive a distribution under the last will and testament. We have to serve them with a copy of the petition and provide them with a copy of the petition. And if they want to, ask for a hearing, they can request a hearing. The judge will set it for a hearing. Once they're served, if we don't have consents, then judge will set it for a hearing, and we go into a hearing, and then, based on the evidence or testimony presented to the judge will decide whether or not to grant the letters of testamentary. From that point, once letters of testamentary are granted, then it gets sent over to the local newspaper and it gets published for 3 weeks. And it's a notice to creditors that gets published. Once creditors are 6 months from the date that letters testamentary were issued, creditors have 6 months to file claims against the estate.
Okay.
If you know of any creditors are known to you, then you must provide those creditors with notice as well also. Usually as the attorney representing the petitioner, I will go ahead and do that for my clients instead of asking my clients to do that.
Gotcha.
So we notify the creditors, and then we send the notice of creditors to the newspaper and it gets published. And so during that time, the personal representative of the estate should secure the assets of the estate, generally get a tax ID number to open a bank account for the estate, an estate bank account, so all funds can be deposited into that estate account. And then any expenses for the estate should be paid out of that account, and records should be kept for every transaction, whether it's a deposit, whether it's a credit, whether you sold something, a bill of sale, whatever it may be. Keep records for every bit of that. And once the 6-month deadline but as a personal representative, you have a fiduciary duty to the estate to secure those assets and protect those assets of the estate. Once those 6 months have passed, then we usually contact the court just to see if there's any claims that have been filed that we may not have received notice of. and then we work to get those creditors paid. Once those creditors are paid, then we start distributing the assets of the estate.
Okay.
If there are deeds, we'll go ahead and prepare a deed, from the personal representative of the estate to whomever it may, whoever is she. And we'll go ahead and make a distribution of all of the assets of the estate. Generally, the personal representative does that, but we provide guidance and oversight with that. And once that is done, then we file a petition for final settlement and discharge. And then those persons, the heirs at law and the persons who were entitled to receive a distribution, they must sign waivers and consents again, saying that, hey, I've received what I was entitled to receive pursuant to the distribution of the will, pursuant to the wishes of the will. I've received what I'm entitled to receive, and I have no objections to the personal representative being relieved of his or her duties of serving as a personal representative of the estate. And so once we get those waivers and consents, we file the petition and those waivers with the court, and then the judge will enter an order relieving that personal representative of their duties to the estate and closing the estate. Again, if we don't have waivers and consent, then we need to, judge will set a hearing, and we have to serve them with our notice of our petition for final settlement.
So, in all actuality, they, even the correct first before any of this payout goes to anyone, correct?
It goes to court costs.
Gotcha.
And legal fees. It goes to any fees with the court.
Gotcha.
If a guardian ad litem has to be appointed, if there's an heir that
Makes
can't
sense.
be found, that we can't serve, we have to serve an heir by publication, then the judge will appoint a guardian ad litem to represent that heir, or any unknown heirs or any heirs that we don't know their whereabouts. Any fees like that, court representatives, they have to be paid from the estate first.
Okay.
And in the wills, it depends on how the will is written. The majority of our wills are going to say that no bond, the personal representative is not required to be bonded. And then the majority of them are going to say that the personal representative is not required to file an inventory with the court. So assuming that is the case, then also in the will, they may or may not be able to charge an administrator's fee, the personal representative.
Gotcha.
That's usually directed in the will. So anyway, if they're allowed to charge an administrator's fee, then the personal representative may charge a small percentage fee for handling and conducting the business of the estate and wrapping up the estate affairs.
All right, so what we've talked about here is pretty much you gave step by step what this would look like if it does go to probate and an estate does. But in a quick scenario, recapping it all, what is the best way to avoid all the conflict and everything and this thing go smoothly as possible? If you can answer that in a quick way.
Yeah, that's kind of more difficult is, if we have some people who are elderly.
Gotcha.
I have a lot of elderlies who will come in and will prepare deeds conveying their property to their children and reserving to themselves a life estate. And then what happens is upon their death, their life estate terminates, and then that property automatically belongs to their children,
Gotcha.
or whoever it may be that they convey that property to in a deed.
That would definitely get you ahead of the curve, so to speak, with the situation.
Yes, yes.
Gotcha, absolutely. Well, we're going to go ahead and take a quick break, and we'll be right back.
Weac Aviation is a premier paint shop that caters to airplane owners from all over the country. There are 175 projects on our 4-year wait list right now. I'm Jonathan McCormick, proud owner of Weac Aviation and a proud graduate of Gadsden State Community College. I got my start in auto collision repair technology. We have hired many skilled technicians who have come through that program. I give a lot of credit to Gadsden State. It's definitely where I earned my wings.
Just ask me that because that's important to me.
All All right, we are back in now. I've been educated a lot in the last few minutes because I didn't know that process, and unfortunately, I've seen this exact situation within my own family, and it caused people to have a rift, and it don't have to be like that. There's easier ways. So this has been very educational for myself, and I'm sure others that's watching this video, and how this should look, and what happens if it goes this way. But what is the process of probating a will? How does that look?
So that was what we talked about. Are you asking without a will?
Yeah, without a will.
Okay.
I'm sorry.
No, that's okay.
Apologize.
So if someone dies intestate means they died without a will. The process is very similar to as you would if you're filing to probate the will, except when you're petitioning, in that situation you would petition for letters of administration, instead of letters of testamentary. When there is not a will, the petitioner is required to be bonded, and the petitioner is also required to file an inventory with the estate. I mean, with the court. I'm sorry, I keep saying the estate. And so they have to have a surety bond in an amount. There's a minimum amount set by the Alabama Code section that they're required to have a surety bond. If the assets of the estate, excluding real estate, exceeds the amount of that minimum surety bond that's required by law, then to the assets of the estate, not including real estate. Now, if all someone has is real estate, there still has to be a minimum surety bond. Once the judge issues letters of administration in an estate without a will, then at that point, the personal representative of the estate is required to file an inventory with the court.
Okay.
And they're required to provide every single.
So everything in the estate, like even little furniture and
Yes.
everything.
Yes, they're required. Now,
Boy,
sometimes
that would be very difficult.
and sometimes if it's like
Yeah.
whatnots or things,
They may.
if they're not of any significant value, we may say, 12 whatnots or,
Yeah.
a bedroom suit or something like that, and then put a value there. But they have to provide that inventory and the approximate value of those items. And then they also have to file that inventory every so often with the court. Without looking at the code section, I want to say it's 6 months. Every 6 months they have to file. I could be wrong. It could be once a year, but I know it's in the code. And then the surety bond, that is a premium they have to pay yearly. And so when we're filing estates that don't have a will, our objective is to open those estates and close them within that year's time because of those extra expenses. So there are a lot more expenses involved when you're petitioning to probate an estate that doesn't have a will, which is another important reason why it's important for you to have a will for your loved ones when you pass away. It not only helps to save with headaches, you get to choose where your property goes, but you also save your family a lot of money.
So it's actually legitimately more expensive if you do not have a will.
It is legitimately more expensive
Okay.
for your family or for your estate if you do not have a will.
And I'm sure you've seen situations like that where someone didn't have a will, and it just puts more burden and more pain on people who's trying to sort through these things. What's the first order of business for you when you walk in and you see this situation? This is what I would like to call an Armageddon situation. If they have an estate, maybe got some debt, they do not have a will, that's got to be, for you, it's got to make your job a little more difficult there.
It does. And one thing that I always look at as well is, what are the liabilities of the estate?
Gotcha.
Do the debts exceed the value of the estate?
That makes sense.
We're going to be looking at a way to try to not probate the estate.
Gotcha.
Because then you end up with an estate that doesn't have sufficient funds to pay the creditors.
So like
which is an insolvent estate.
So like if they have a very, very nice house that does not have the equity enough in it to pay it off or get close to that, that'd be a situation of what you're talking about, correct?
Yes.
And they still owe a large amount on this house.
And usually what I recommend is that they contact the mortgage company and let the mortgage company know
Gotcha.
that the mortgagee has passed away, and let the mortgage company proceed with foreclosure so that they can gain possession of the home.
And in those situations, the creditor, being the mortgage company, they couldn't come for the deceased at that time, or would they come for the estate?
Creditors also can petition to administer
Okay.
estates,
Okay.
which is interesting. It doesn't happen
See,
that
I
often.
didn't know that.
It doesn't happen often. It has happened. I've handled a few of those before.
Gotcha.
When, especially when there's been like car wreck cases or civil litigation cases where there are judgments, and someone passes away, and whoever it was that obtained the judgment against that person realizes that the estate is sufficient. There's sufficient funds to pay that judgment. The creditor, if some of the family members do not file to petition or do not file to probate the estate, then sometimes the creditors will do that.
Gotcha. See, that's educational for me. I didn't know that.
Yes.
And one of my family situations was very similar to that. And they ended up foreclosing on the house, and the value didn't equal up, and they ended up going on a full foreclosure on it. So it's
Yes.
interesting. See, I didn't know that as well.
And one other thing I'll add is we also now, as in the last couple of years, we also have to provide notice to Medicaid. And so if Medicaid has paid any money for the deceased claim, and if Medicaid has not paid anything, then they will send us an affidavit that we file with the court that says, we haven't paid anything for this decedent.
So someone could be in a medical situation, like maybe a nursing home or something, and were to pass away, is what you're saying in that way. If that's in a nursing home, they would have been paying at that point.
Yeah, I was going to say, generally, when someone's in a nursing home, we'll get into that next week if you want to. That gets into conservatorships and well, not necessarily conservatorships and guardianships, but sort of it does.
Gotcha.
Because what happens is whenever someone has to go into the nursing home, Medicaid, they apply for Medicaid, the value of their estate is to be less than $2,000.
Okay.
And so whatever they have in their estate that exceeds $2,000, they have to deplete those assets before they qualify for Medicaid. And so what we've had, just quite often actually, is someone passes away, they have a home, not passes away, but they go into the nursing home, they have a home,
Gotcha.
and Medicaid will qualify them for Medicaid and start covering their nursing home care. And then Medicaid files a lien against the house. We hear, people say Medicaid took the house. Medicaid files a lien against the house. The house still belongs to, whomever it is.
Gotcha. So you're looking at a situation where if they go in, they put a lien against the house, but the situation would still be in the person's hands that's going into the nursing home, so to speak.
Correct.
To
yes.
deplete it.
Yes,
Right.
that's
Well,
correct.
that makes sense.
Or family members, generally.
Or family members, yeah.
Yes.
Man, this has been very educational for myself. But just in closing here, we got a few more seconds before we close down. This has been very educational for myself, and I'm sure many others. But if you had some words of advice in closing, what would you tell people? The best case scenario.
I would say, I don't care what age you are, a last will and testament prepared.
And also at the bank as well.
Contact the bank, and if you have other people on your bank account, make sure they're listed as a joint owner with rights to survivorship.
Not just an authorized user.
Correct.
Shirley, this has been absolutely fantastic. I've really enjoyed it. I've been educated a lot, and I'm sure I've actually have a lot of people who's going to want to see this. So I thank you so much, and we'll be back here, God willing, each and every week with another edition of the Shirley Millwood Show is what I like to call it, but it's balancing the scales of justice.
And thank you for being here with me tonight,
Appreciate
Bo.
you.
It's
Thank
been
you so
nice.
much.
Yes, thank you.